Hello, everyone. My name is Marcio Katz. I'm the Chief Operating Officer for Get Global International, and we are here for another podcast, another episode of our Data Privacy podcast. We have the pleasure to be with Kirk today. How are you today, Kirk?
I am fine, thank you. How about you?
Okay, that's great. That's good. Today we're going to talk about something very important. We are going to talk about the bipartisan U.S. data privacy bill. But my first question is, Kirk, how did data privacy came across your professional life? How did you get involved with data privacy?
So, I have actually been a privacy lawyer for more than 20 years at this point. But at the same time, since I'm old, I was already about a dozen years into my career before I did any privacy work. I was already a partner at a big DC law firm doing other kinds of work. I did insurance work and I did a lot of healthcare work, and I had some exposure to some health privacy issues, mainly some state laws in the United States. We had a history of state privacy laws that go back, many years on very narrow subjects. And the first two federal privacy laws in the United States, which covered specific sectors, financial services and healthcare, I had clients in both of those areas. It was a new field. Nobody knew much of anything about it. I knew a little bit. So something I started doing at that point, and then the field became a much bigger field over time.
Yeah, okay, I see. And what's your current position nowadays?
Sure. I am a partner at the law firm of WilmerHale in Washington, D.C. We're a global law firm, but I'm based in Washington, D.C. I am the co-chair of our global cybersecurity and privacy practice group. I'm also the co-chair of our big data group. And so I manage a practice, across the country, across the world, dealing with just about any privacy and security issue you can think of at this point. I mean, it's possible you could ask me something that we haven't dealt with before, but it would take you a few chances, and you might not even find one. So,
Interesting. Well, as far as I understood, you have a long career on data privacy. So now we are at a certain point here in the US that things might change. It seems that people are getting very excited about this bipartisan data privacy bill. But I want to hear from you. What do you think about this whole thing going on?
sure. Um, well, people getting excited about it is an interesting. I mean, the U.S. Congress has been having a debate about a national privacy law since the mid 1990s. Um, it came up when the internet first got started in the United States, and nothing really happened. The only meaningful law that went into effect at that point was a law in the United States called the CAPO law, which regulates the privacy of children under the age of 13. I don't know how many of your listeners have children who are, anywhere near that age. I know that my kids, with the day they turned 13, did not become adults, but the law treats them as adults for that purpose. So, um, since then in the United States, and I think this is an important part of understanding, particularly for your listeners who are outside the United States. We have lots of laws in the United States. We have dozens of laws in the United States. It's one of the reasons why it's so hard to be in my field in the United States. But those laws were in a couple of categories. They were sector laws, financial services, healthcare, education, for example. They were laws about certain kinds of practices like telephone marketing or email marketing, or they were laws about particular kinds of data, categories of data, children's data, biometric data, genetic information. I think my favorite law in the United States is a law that actually protects video rental records. Not really relevant for my students who
Okay.
don't know what a video rental is, but back in the 1990s, there was a journalist who went to a video store and got the rental records of a Supreme Court nominee, and that's those records, showed some things that the judge was not that excited about. And the members of Congress in the United States, being, self-protective, if nothing else, thought, I could be next. So they passed a law about video rental records. And for many years, your video rental records in the United States had more protection than any other piece of data about you, your healthcare, your financial, anything. So we have lots and lots and lots of laws in the United States. But what we haven't had is a single national law, something like GDPR in Europe that covers everybody, everybody all the time. There's been different points in the last 20 years where Congress has gotten more or less excited about a privacy law. There were a series of years in like 2013, 14, 15, 16, where there would be some major, either it would be a security breach or some other major privacy incident. And, some peer of mine would get on the media and say, oh, this is the tipping point. Now we're going to have a law. And they were wrong every single time. Then we started to have the state laws in the United States. Well, we had GDPR, which put a lot of pressure on the United States, but we didn't do anything about GDPR. Then we have the state laws, California being the first. They're not GDPR, but they're little mini versions of something that's sort of a little bit like GDPR. We now have 5 of those state laws, although most of them aren't going into effect until next year. My guess is a year from now we'll have 10, 8 or 10, something like that. But in the last, year or two, there's been more movement on a U.S. national privacy law. There's been a couple of sticking points. We'll talk about those in a minute, I suspect, that have sort of held up the law moving forward. This bill that you're mentioning is a recent development where members of both the House and the Senate and members of both parties came together on a potential compromise on the 2 big issues. And so there's some momentum now that there's some agreement across the parties and across the 2 houses of Congress. We can talk about where that's going to go at this point, but it's moving forward a little bit. We can debate how much the little bit is.
Okay. I haven't heard so for anyone who were able to explain the background about data privacy in the U.S. in such a pragmatical way, and I really enjoy that. Actually, I usually say that there are different standards and different ways of regulating data privacy all around the world. There is the European standard, the GDPR, that comes with a more comprehensive data privacy legislation that pretty much says that you can process personal data if you fit in at least one of the 6 legal grounds. So there are 6 different possibilities that you would be able to process personal data. And this standard, once you do it, process the personal data under a certain legal base, it goes to a different category that it's going to give you some boundaries on how you should process the personal data. So things that you can do, things that you can't do. And the third group of obligations are the individual's right, what kind of rights each person, each subject has regarding its own personal data. So that's pretty much how the European standard works. Yep. People usually say that the US doesn't regulate how companies process personal data. And for me, that's a huge mistake. It's just different. As you said, it's more sectorial, but it doesn't mean that there is no regulation, right?
Well, it's more complicated than that. I mean, there are laws that cover lots of things. It's also clear that there are lots of companies who fall in the gaps, and there is not a specific law that applies to them. Now, that's not the end of the story in the United States, and that's something I have to get across to a lot of companies who, will say, "Well, I'm not a healthcare company, I'm not a bank, so I can do anything I want," right? And we do have other regulators. We have in the United States, we have at the national level, we have the Federal Trade Commission. They have very broad authority to regulate unfair and deceptive trade practices. They don't need a specific law that says, this store can't do that thing. But at the same time, they have standards, and they have, there's the ability of companies to challenge it. So it's not that there aren't rules and isn't anybody watching you, but it's not a specific law. There are state attorneys general that have somewhat similar authority. They have very broad authority in the consumer protection area. And again, they don't necessarily need a specific law, but if they, that's where my job comes in, right? I mean, the Federal Trade Commission or the state attorney general will say to one of my clients, we think that something you did was unfair and deceptive in some way. And my job is to persuade them that that's not true, that we met our standards, we described what we were doing, we said what we were doing, we said it accurately, we haven't done anything beyond that, we're not causing, a variety of ways that you can defend that. So it's a little squishier, certainly. If you took all of the laws that exist in the United States and you layered them on top of each other, and you also put on the Federal Trade Commission authority and the state attorney general authority, there are still some gaps. I mean, for example, we have nonprofits in the United States. The nonprofits aren't subject to the Federal Trade Commission authority. They're not subject to most of the laws that exist. The state attorneys general might be able to police a nonprofit that did something bad. That's a potential gap. But if you really layered everything on, there isn't much that's in the gap. Now, you could certainly take the position that the Federal Trade Commission's authority is too vague, and that means that companies can do too much. That's a fair argument. That's a fair position. And the FTC would like to have more specific standards. They may be issuing their own standards over the next few years. So it's a really complicated environment. And that's not to say that GDPR isn't complicated, but it's complicated in a different way. At least there's one law that we're all trying to figure it out. Doesn't mean that we're going to think about it the same way, or that everyone's going to, even the regulators don't think about it the same way. But in the United States, we have so many laws. And so, that's good news and bad news. I mean, one of the things I say when I talk about this topic in general is my view is that the state of U.S. privacy law right now in the United States is reasonably bad for consumers, reasonably bad for businesses, and it's really only good for me.
Yep.
Because I'm a privacy lawyer, and everybody needs my help because it's too hard to figure out. But there's no reason that public policy should be written to favor lawyers helping people figure it out. So I'd rather see, just as a policy matter, I'd rather see more clarity. I'd rather see one law. One of the things I say is I don't even care what it says, but I care a little bit. But I mean, but if we all have the same law, that's probably a good thing. Now, there are some caveats to that. I mean, I deal a lot with the healthcare privacy rules in the United States. The healthcare privacy rules are, first of all, they're pretty protective of patients, and they're written very carefully for the healthcare industry. And what that means is that they're designed to provide very strong privacy protections, but also let the healthcare system work well and work efficiently and work relatively inexpensively, which is good for patients. It's not only good for the industry, but it's good for patients. That's really hard to do. And you can't take those rules and say, we're going to make that work for a bank or a restaurant or a retailer, because they don't do it the same way. And we don't have the same balance, the same set of interests involved. So that's one of the things that I think GDPR suffers from. GDPR, I like to say that the HIPAA rules in the United States have a lot of nuance, subtlety for the field. GDPR has no subtlety. Now, you could say, well, everybody can build their own case for, but it's one rule that's designed to cover everything. that may be better in some ways, but you are losing that nuance. And so that's a trade-off. And I'm not sure what the right answer is, but I can tell you that if you do it this way, you lose some of that nuance, and there is a negative to that.
Yeah, but that's my question. Which standard would you prefer? I mean, which one do you, aside the fact that you are a data privacy lawyer that works with this whole mess that the US data privacy regulation is, which is not good for me and for our company, for example, because we are data privacy consultants. So we try to help companies comply with the legislation. When the legislation is not clear,
Yep.
there isn't much we can do because they are going to do whatever they want.
That's my whole job, is when the law doesn't tell you the answer. So
yeah, that's pretty much what I'm trying to say. But what's your opinion? What standard would be better? Because I feel that if you don't regulate, I kind of like that, maybe because I'm a little bit more liberal. But when you regulate just part of it and it's not so clear, it becomes a mess and it's horrible for the business.
Yeah, that's fair. I mean, I think there are some elements of that so I think it would be useful to have a law that covered everybody. So that's one principle. And I don't think the U.S. has that. You may eventually, again, if my layering approach, most people are covered by something, but they're not covered by the same thing. I would like to find an approach, and I have some, theories about this, but it's probably left to people that are smarter than I am to figure it out. But I would like, the way I describe the healthcare rules is that they have specific principles for the context of the healthcare industry. And I would like to find some way in the law to generalize that idea of context, to say that when you go to a bank, there's certain things that is normal for the bank to do, and that should be easy for the bank to do. You don't, you like one of the principles in the healthcare rules is we're not going to ask your permission as a patient to do all the normal stuff that happens in healthcare. The doctor's going to treat you. The doctor's going to submit the bill. The insurance company's going to pay it.
We got to treat you. We got to save you. We got.
We're not. We're going to do. That's going to be normal, and that's going to be easy. And if the hospital wants to do something that's not normal, then they need your permission. I like that approach a lot. And there's a way it's written in the healthcare rules that covers the healthcare industry. But those rules would that the way the healthcare rule is told healthcare industry is told what's normal, that wouldn't make any sense for a bank. So we need a way to generalize that. I would like to see that. And again, this idea of context is one example.
Yeah, but I see that on the general data protection regulation. When one of the legal bases is execution of contract.
Yeah, so but it's much more than contract. It's much more than contracts.
No, I understand that. But if I might go to a hospital, and that means that we are going to sign a contract, right? They got to treat me. There is a service that's going to be provided. So
yeah, it's not a regular contract.
Personal data, not a regular contract, definitely not. But there is a service that's going to be provided, and they definitely need to process some sort of personal data to execute the contract. If I go to a bank, the same thing. It's a different contract, a different situation, but there are regular things that come up with this service that's going to be provided. So I feel that this specific legal base execution of contract might give you the possibility to analyze the nuances of that specific service.
Yeah.
Besides that, the general data protection regulation, most people think it's a law, and it's not a law. It's a regulation. What's the difference? As an European lawyer, I can tell you that a law is something that the whole country will have to follow. But the regulation, when it comes to the community kind of law, the European law, it's just the principles. And one of the articles of the GDPR says that for some specific topics, each country can regulate it. So that means that you are going to pick up what kind of nuances you want to give to different situations. So I feel that the GDPR might give you
I mean,
some tools to deal with this.
I think there's some of that. I'm not sure the country one is the way to do that. I mean
Okay.
that says that Spain can treat healthcare differently than France can treat healthcare. That doesn't say healthcare is different
Definitely
than banking.
not.
So I don't know,
Uh-huh.
but I mean, legitimate interest. There's a variety of ways you could analogize
Yeah,
that.
definitely. We are just trying to come up with
Yeah,
one standard. I mean,
we
how do we
don't.
think?
Yeah, so we don't have that in the United States, and we don't,
Mhm.
and you asked what what I think is the better answer.
Yep.
I
Hmm.
I like the healthcare rules very much for the healthcare industry. I would like to learn a lesson from how those have worked well and try to translate that to a broader audience. How
Hmm.
we're going to do that is not yet clear. This idea of context is one of the options. There's some principles in this consensus bill you're talking about, something called a duty of loyalty, which professors Richard and Hartzog have been writing about for a number of years. And, that's another variation on that theme. I think it's I've talked with that a lot with my friends who are the authors of that theory, and I think it may be too limiting, but it's but again, it's a different idea of that. So I think that would be a useful way to try to have a principle that makes sense for a wide range of different kinds of activities. And so that's, I think,
Hmm.
the goal that again, if I were in charge of this, that's what I'd be trying to do. Um,
Perfect.
I get asked by law students, if there's a national privacy law, is that going to mean there's not going to be a need for privacy lawyers? And I can point to GDPR and say, no, there's a need for more privacy lawyers under GDPR. And
Definitely.
is it possible that 50 years from now we're going to have learned everything about maybe I'll be retired, it won't matter to me, but it's possible. But no, a national law in the United States will explode the need for privacy lawyers, because there's going to be all these companies that think they don't really have any obligations now have obligations. And all the companies that already had them are going to have new obligations. And so
And compliance professionals as well. I mean, a lot of people will
absolutely.
try to help the companies to comply with
Well,
the
that's one of
legislation.
the interesting. I don't know how much you see this, and I think it's relevant in other countries as well. It's a big issue in the United States, which is um, lots of the jobs on privacy compliance are legal like jobs, but they don't have to be done by a lawyer. And so we're seeing both law students who go in the direction of providing services that aren't automatically legal services, but where legal training is useful and appropriate and often desired by the companies. We're also seeing people who are not lawyers build a career path in this area. And some of the chief privacy officers of some of the biggest companies in the United States are not lawyers, and they don't have to be. They have to think like how a lawyer typically thinks, but there are things you can do, and the skill set to be a good privacy person is expand. It's now a really long list of skills that you need. It's really hard. So
Yep.
you need
Yeah.
very talented people at the top of that chain.
Yeah. Because to work as a data privacy professional, you got to understand what are the obligations. So you got to understand at least how the law works. But the things that you are going to change in the way that the company does business, process, personnel, software that you might have to implement to help with all these obligations, it's not a legal matter. So this is more management. So I usually say that there is a data privacy management that area that it doesn't have to be done
Right.
by a lawyer, right?
No, I agree with that, and I also find myself as a lawyer, I'm part public relations, I'm part business strategy, I'm part compliance, I'm part psychology, I'm part management, I'm part computer science. I'm not a good computer scientist, but I mean, I'm part technology person. It's so it's really a
Cybersecurity
mix
and so on.
of it's a broad mix of skills that you need. And now, at the same time, as the field is growing, it also means that there's lots of subsets. And so you don't necessarily have to do all of those things. I mean, I think the people at the top tend to have
Mm-hmm.
all of those skills, and it's it's funny. I say this a lot again to talking about with law students and stuff. When I started in this field, I needed to learn 2 laws. I can learn 2 laws. It's not that hard to learn 2 laws. And then each time there was a new law, I could learn the new law. I feel bad for my young associates because they have to learn 50 laws, and that's really hard. So
yeah, definitely. And now they gotta learn the different skills because
so they don't really have to learn all 50. They have the opportunity. If when I was starting, I only knew one of the 2 laws, my career options were very limited. Now, if somebody really is good at 3 of those 50, they can have a great career.
yeah.
So it provides, I
Yeah.
think, a lot more flexibility.
Okay, so and how far is this bipartisan U.S. data privacy bill far from what we've been discussing? I mean, does it look like what we are trying
Yeah,
to come up with, or?
well, I think there's 2 elements to that there have been very specific. I mean, there's been bills introduced for the last 3, 4, 5 years. So it's not that the detail of the law is different. It's that you now have, you referenced to bipartisan. We now have multiple people from different houses of Congress and different parties on the same bill. So it's not necessarily that the bill itself is more specific or more detailed. It's just that it's further along in getting people to agree to it. And so the major element of that is that there's been 2 issues that have been dominating the discussion in the United States, and that until this bill have been viewed as the reasons we didn't have a law. So the 2 issues are something called preemption. Not really that relevant in EU, but preemption is essentially, will the national law replace the state laws or be in addition to the state laws? And one party wanted to replace the state laws, one party wanted to keep the state laws. And then the second question involved what's called a private right of action, the ability of a consumer to sue for a violation of the law. There's going to be regulatory enforcement. We all knew that. There was always going to be regulatory enforcement. You can't really have a law without regulatory enforcement.
Right, and so on.
Well, it's going to be FTC under this bill, but the question was, would a consumer be able to sue? And so what they've got in this bill is they've got a compromise provision on each of those points. That doesn't mean everyone's going to agree to it, but it's a compromise position. It's got more. It's got a bunch of preemption. For the most part, it's preempting the state laws. There are some exceptions to that, and some of those exceptions are important. But it's preempting these general state privacy laws, and it's going to ultimately give consumers a private right of action, but that's delayed for a number of years to let the law sort of figure itself out a little bit. Again, it's not an unreasonable compromise. I don't know if it's going to end up being the right answer, and I don't know whether they're going to get So there's just this sense that because there's been a compromise proposal that people from both parties have bought into at this point, that maybe that means that the whole bill will move forward. My concern is a little different, which is my concern is that we've spent so much time and energy on those 2 issues that we haven't spent enough time on everything else, which is the real substance of the law. And so, the bill, I think, again, I think just if you sort of read a cross section of comments, I think it is a reasonably protective law for consumers. It doesn't apply to everybody, but it applies to lots of people. It fills in most of the gaps. It lets the companies like the healthcare companies, the financial services companies who are regulated by other federal laws will still be regulated by the other federal laws. That's a choice. I mean, we could decide to do it differently, but and again, there's some good provisions in there. I don't think it's a perfect bill. There's a lot of discussion among sort of my colleagues.
Can you list some of the provisions in this law?
Sure. There. You mentioned individual rights. There's a bunch of individual rights. That's generally a pretty good set of. I think that it's not that there isn't still discussion on that, but we're getting to a consensus on those rights. There is this duty of loyalty. There's some privacy by design elements. There is the preservation of the existing laws, which again is an important choice. There's a carve out from the preemption of some other laws. Some of those are going to cause some real problems, and I don't know that Congress has thought through the exceptions there, because I think that's going to be some challenges. The FTC is continuing to be the primary regulator. That was a question. I mean, there were, in Europe, they've created data protection agencies that are specific for data protection.
Even in California.
California is getting there. We didn't have that originally, but we have that in the EU, and the FTC does a lot more than data protection. And so there was a question as to whether you were going to create a whole new federal agency. At least in this bill, that's not what they did. They're going to have the FTC run it. I personally think that's the right answer. The FTC, you can challenge them, you can debate what they're doing, you can take issue with particular steps, but they know what they're doing. They're smart people. They've got a lot of experience. They've got a lot of knowledge. And I don't think it makes all that much sense to throw them out and start over with somebody else. But that's an open question right now. This law is right now proposing the FTC. There's a lot of elements where there's going to be future regulations. So this law, even if it was passed as it's written right now, is not the end of the discussion. There's still 8 or 10 major elements that the FTC is going to be giving detail on and providing regulations on and thinking about that. So again, it's moving along. There are folks who have said, "Oh, it's going to pass this year." I'll be surprised if it passes this year. I won't be astonished if it passes this year. But I think it's
so many things to deal.
Well, that's
a war going on, inflation, and many other things.
Well, you have. Anytime you're thinking about the United States Congress, you have at least two questions. One is, are they going to do anything about anything? That's sort of your point. There's so much going on. Privacy, a privacy law is really important. At the same time, there's no imperative, there's no deadline, there's nothing that's going to say, oh my God, if we don't pass it tomorrow, it's the end of the world. So they don't have to pass it now. And there's lots of other things going on. If you get past all of that, and this the compromise bipartisan bill is designed to get past some of that, you still have to agree on everything. And the main issue there is that there's one very important person in Congress. There's a senator who's the chair of one of the relevant committees, who's been very vocal about these issues for many years. She doesn't agree with the compromise bill. She is not on board with that, and she has said she won't support it. So the question, the short-term question on substance is whether she's going to be able to get other stronger protections added to the bill. And if she does that, will the people that have signed on to the compromise jump off the compromise? So that's what we're dealing with over the next month, 2 months, 3 months, certainly going into the fall. If they get to a point where they have her agreement on a big bill, is there a possibility it's going to pass? Sure, absolutely. Mm-hmm. So we're gonna watch that. It is a reasonable. There are. In a Congress that doesn't agree on much of anything, there are privacy interests in both parties. There are lots of privacy interests in both parties. And there are some situations where the Republicans are almost more protective, but, it's not a specifically partisan issue on the idea of protecting privacy rights. Some of the details about how you do that has more of a partisan component. And so, unlike lots of what goes on Capitol Hill, you could see a path forward to a bill where the both parties would come together on that. I'll say, what I've been saying as a prediction is better than 50-50 chance of a national privacy law during this term of the Biden administration. But that means before January of 2025.
25. That's a long way.
Now, to be fair, I also think that the sweet spot is between now and a year from now. Once you, maybe the end of 2023. As soon as you get past there, you're into the presidential election. I don't think anything's going to happen there. So I think that you've got a window right now where the Democrats have they don't have control, as we know from lots of other discussions. But you could get a bill that with Democrats on both sides of the hill, even if there's some change in that next year and the Republicans have more control. I'm not sure that means that this bill doesn't still move forward. And I think there's a possibility of a time period before the presidential election gets too far going where you could get an agreement on that. If it carries over into 2024, I think the odds go down again. But
how does the pressure that comes from Europe might help in this whole process?
Yeah, it's there's been two interesting developments that are sort of tangents, and I'm not really sure how to deal with them. So the issue with Europe is the data transfer issues, where European courts have said that basically that it's very hard to transfer data from Europe to the United States because
it's not secure.
Well, it's not that it's not. I mean, that's not really. I would say it's because there's too much possible access by U.S. law enforcement. That's not a security issue per se, because the data.
No. When they say secure, is mean the legislation doesn't protect.
Yeah.
The subject.
So this compromise bill does nothing about that point. Now
that would be my next question. If it solves the problem.
well, but it's interesting. Then you have this other path in Europe, which is this idea of adequacy. And when there's been an adequacy determination in the past, it's not clear to me how much that law enforcement stuff was looked at, because different people. So there is a path there that may help to solve that problem. Something to think about, something we're clearly going to be watching. The other issue, which has been occupying a ton of my time this week, is the Supreme Court decision in the Dobbs case, which is all of a sudden creating, not all of a sudden, it's exacerbating to a significant degree a pre-existing concern about certain kinds of privacy interests. And the privacy interests, again, most of the U.S. privacy law discussion, most of this bill is a commercial discussion. What can companies do with consumer data? And now what we're seeing with the Dobbs decision is renewed questions about what the U.S. government or the state governments can access. And that's just it's a different variable. We haven't seen that much directly in these laws that would deal with that issue, but all of a sudden there's a ton of attention being paid to that. There's some separate bills that are trying to restrict that issue, but that's a really hard issue. I mean, again, I'm completely sympathetic to trying to protect that data and to make sure that the idea that your personal health data could be provided to law enforcement is a terrible answer. So we need to figure out how to do that. I'm not sure that's going to be in this national privacy law, or it wasn't in the national privacy law until the Dobbs case comes out. And so now the question is that law going to have another completely different complication? And because that issue is such a partisan issue, is that going to blow up whatever agreement there is on the compromise? So all these the other big moving piece, which is also something to think about, it's a little different issue, is artificial intelligence in general. Is this national privacy law going to regulate artificial intelligence? And there are clearly some elements of privacy in that, but there's also lots of things that aren't privacy in the AI discussion. Mm-hmm. And so I'm not sure that Congress should try to tackle artificial intelligence and discrimination issues in this national privacy law, because I think if they do, they're not going to do a good job with it. And it's going to make it harder to get the privacy law.
Well, the regulation of artificial intelligence is also something that's being discussed in different parts of the world.
Sure,
and
absolutely.
Personal data is just a part of this whole thing, because if you think about regulating artificial intelligence, it goes beyond personal data. I mean, there are so many other things to think about, and vice versa. When you talk about personal data, artificial intelligence is just one part of the whole thing, because there are many other ways to process personal data. But definitely, when we put together personal data and artificial intelligence, that make things even more complicated, I would say.
Yeah. And so
But
anything that makes this debate in the United States more complicated makes it less likely that the law gets
yeah.
passed. And
Hmm.
that's just interesting. I think there's we have this one senator who's the holdout, and again, I totally understand the position she's in, but if the result of her being a holdout is that we don't pass the law at all,
Hmm.
that's not helpful for privacy rights either. And so it's a tricky it's so many tricky elements.
So you feel that if this bill passed and come into law, effective, it's not going to solve the problem with Europe. You don't
Well,
feel that?
I don't know. I don't want to be quite that pessimistic. I'm not.
Mm.
I don't know if it will or won't. I mean, it is certainly feasible for the United States, if this law gets passed, to go seek an adequacy determination. They've never sought one before. There's this expectation. I mean, we don't have one now, and so we don't get the benefit of an adequacy determination. It's not that Europe has turned us down; it's that we've never sought one, to my knowledge. So we could seek one now. I'm not sure how that's going to play out. I mean, again, this is getting outside of my wheelhouse, but I mean, my impression is that there is a disconnect of sorts between the European privacy regulators and the European courts, and that the European privacy regulators want to protect privacy, but also understand that the world needs to move, and you could structure things in a way that's actually bad for people in Europe by being too privacy protective. And so the privacy regulators will be more involved in the adequacy review. So you may get that. I think there's a possibility there. There's a parallel discussion with the Biden administration about, the transatlantic data flows that had a lot of publicity. How long has that been now? 3, 4, or 5 months, and then it's gone quiet for
I
a
would
while.
say.
So there's just so many moving pieces. I mean, I guess it goes back to one of the points I was making earlier, which is, give me one law. The fact that there's all these
Give me
different laws,
something.
the fact that there's all these different laws in different countries doesn't help anybody either. I mean, it just makes it, again, it helps the lawyers. It just makes it harder for everyone to do their job. It makes it harder to do business. There's no chance that consumers can understand all this stuff. I mean,
Mhm.
it's a little different because consumers are, if you're a Venezuelan or you're a Singaporean or you're an African, you only have one set of laws for you, but as you try to deal with things around, it's too hard. And so, I think that's one of the other questions we're dealing with in the United States is, what role should a consumer play in protecting their own privacy?
Mhm.
U.S. law right now puts a lot of that burden on consumers, and there is a growing recognition that makes no sense, that we can't
Yeah.
do that. But
Yeah.
I'm not sure you want to take them out entirely.
In some other countries, the situation is just crazy because companies can be sued by the consumer, by their FTC, by their data privacy authority, and by the general attorney. I mean, so the fire can comes from different guns and different places. So that makes things even more complicated. So I feel that we need to find here in the US the balance between
Yeah.
all these things. We've seen things in some other countries, but we know that US has its own things. So, but anyway, it's been more than 40 minutes that we've been talking about it. So that's pretty much it, Kirk. I mean, it was a great conversation. I learned a lot. Thank you so much again to be with us.
Thanks
It
for
was a
having me. I
pleasure.
appreciate the opportunity to be here.
Okay, that's great. So thank you, everyone. Thank you for being here with us live on LinkedIn. And we are also going to upload this episode on Spotify. Thank you so much, guys. Bye bye.